ಈ ಆರ್ಟಿಕಲ್ ಓದಿದ್ರೆ ಹರೀಶ್, ಮ್ಯಾಕ್ರೋ ಎಕನಾಮಿಕ್ ರೀಸನ್ಸ್ ಜಾಬ್ ಕ್ರೈಸಿಸ್. ಅಲ್ಲ, ನಿನ್ನೆ ಕವರ್ ಮಾಡಿದೆ. ಓಕೆ. So this is I am again taking 25th paper and also 26th paper. So this is actually a potential question for prelims. Center plans to revive tax cuts on sugar exports. ಏನಿದು? Anyone? Why tax cuts on sugar exports? So for exporting, there are different category. Like some items you can freely export, no restrictions. For some items, there is a restrictions. Okay. So always government will be changing that stand. So recently means sugar was removed from this free category. It means sweeteners. Okay. So why now they are reviving? What is the reason for that? So what they can ask? So here the free category and a restricted category, both are there. So you all know that why these categories exist. Usually what type of items we put under restricted category? No, you mean to say that with some permission you can take that is banned category. Banned category is different. Restricted means on certain conditions you can export, like quota control, only 100 kg, only 100 ton, like that, quota control. Okay. So suppose inflation is there, that means price rise is there in the country. So at that time, so definitely they will put restrictions, right? Because we are facing the scarcity in the local, that is domestic. So they will not allow that to export. Okay. So then why, what is this news? That is one, that is general question. Always with respect to inflation, they will ask these questions. And why they are thinking about tax cut rate for the export of tea? What is the reason for that? Simple reasons are economically complex and irrelevant, but you need to just analyze and answer. So what may be the reason? So obviously export, the by default export gives us money. Like so then why till now they did not do that? What is the reason for that?
Maybe that because of production before.
That's what. So basically, when the production level is low or inflation is there, at that time they will put it on restriction. Whenever it is possible, whenever it is eases easily, they will allow them. Okay. So they are talking about sugar as well as tea. For tea also they are trying to tax cut. That means again they are boosting the exports. So I am expecting you to tell that. Just a few days back we discussed about export shrink. Imports also falling, exports also falling. Artha agata? So government has to do something. They have to take measures to correct it. ನೀವು ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕಲ್ತ್ಕೊಳ್ಳಿ ಅಂತ. ಇದು ಇವತ್ತು ಅಷ್ಟೇ, ಮತ್ತೆ ಇನ್ನೊಂದು ವರ್ಷ ಮುಂದಿನ ವರ್ಷ ಬಿಟ್ರೆ ಮತ್ತೆ ಬೇರೆ ನ್ಯೂಸ್. ಬಟ್ ಕಾನ್ಸೆಪ್ಟ್ ರಿಮೇನ್ಸ್ ದ ಸೇಮ್. So recently only we have seen that exports are also falling, imports are also falling. So that means government has to do something, right? So now they're using. Okay. So remission of duties and taxes on export products scheme is there. That is launched in 2021. Okay. Again, to boost up export only. But you must be knowing there is some scheme. Remission of duties and taxes on export products. Okay. Which is aimed at ensuring that no domestic taxes are added on goods shipments meant for export. Authorities had denied benefits under the scheme to sugar exporters after the sweetener was removed from the free category. So this is understood. If it is in free category, this scheme is applicable. Intadana prelims question. If product should be under free category, then they will give the benefit to them. Means cost kadame agate, exporters will get. Again, explicitly they are saying any item which is restricted for this benefit. Once sugar was brought into the restricted list, it has been prevented. Enama?
So free category as
Come again?
So free category as in?
Free category means which you can easily export without any restrictions. Okay. So usually like sugar is an essential product. So they will not always put it under free category because domestic consumption itself is very high. So if you allow it to export and also see connect the things for ethanol production, sugarcane is being used. So there also diversion. So reasons may be, it may be anything. So scarcity because of that, or the production because of lack of water, means hydration is not available, extreme weather events. So yield will be low for the sugarcane. So whatever may be the reason, so if it is hurting the domestic economy, they will put it under restricted mode. So in 2022, they have put it under restricted mode. Okay. So now this, as per this scheme, they are saying that it is not under free scheme, means free category. So we will not allow it to, means tax exemption or duty, that is not given. Okay. But now they are demanding. The sugar industry has appealed to the Department of Food and Public Distribution to change the nature of restriction. Okay. Even High Court directed, yes, you allow them to give that benefits and all. Okay. So just I wanted to highlight you that there is a possibility to ask question in this. So you must know about this scheme and understand some category. Or in mains, you can write this line itself. There is a scheme which allows boost exports. Okay. But whenever there is a scarcity, there is an option to put it under restricted mode. Okay. See, the moment you study something, think about how the question can be asked in prelims, how I have to write the line in the mains. If you do this habit, your answer writing becomes very easy. Yes, India's revised criminal law proposals. Okay, so British era criminal laws were put to an end. So we are having three new bills. One is Bharatiya Nyaya Samhita, which is replacing IPC, Indian Penal Code. Another is Nagarika Suraksha Samhita. So that is replacing CRPC, Criminal Procedure Code, and Saksha Samhita, replacing Evidence Act. Okay. So we discussed so many things. Some problems were there earlier. So now they have changed many things, and the final version was passed very recently. Okay. So let us see what all the changes they have done. See, almost 50 recommended changes were uh, modified, that is amended in this bill. Okay. So let us see one by one. Bharatiya Nyaya Samhita. Okay, that is nothing but IPC, Indian Penal Code. So what is the purpose of this bill? What is the purpose? So penal code. What is the meaning of that? What is the penalty for a particular crime? See, basic ಏನಿದೆ ಅಂತ ಅರ್ಥಕ್ಕೆ ಹಾಕೊಳ್ಳಿ first. What I can expect in this book, in this bill, in this act. So you can expect. So okay, what are the different type of punishments? The definition of those punishments and what type of penalty they have to experience. Okay, so then only it becomes easy for you to remember. So Nagarika Suraksha Samhita, that is about citizen rights constitutional ಇದೆ ಅಮ್ಮ. What you can expect in that bill? Whenever a crime takes place, what procedure you have to follow? How to do? Procedures to follow. ತಲೆಗೆ ಹಾಕೊಳ್ಳಿ, ಸುಮ್ನೆ ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋದು, ಅಲ್ಲೋಗಿ ಏನೋ ಅಸಂಪ್ಷನ್ ಮಾಡೋದಲ್ಲ. ನೋಡಿ ಈಗ ಮಾಡಿದ್ವಿ, ಸುರಕ್ಷಾ ಅಂತ ತಕ್ಷಣ ರೈಟ್ಸ್ ಅಂದ್ಬಿಟ್ಟು. The purpose is about, sir, rights are given in constitution. Why they will write it in CRPC? Means here Nagarika Suraksha Samhita. So this is about procedures. Another is Saksha Samhita, evidence. So what type of evidence is allowed? What is not allowed? Whether WhatsApp message can be considered as evidence, right? So evidence, what is or whose evidence is considered? Family member evidence should we take or not? Or the culprit, one who is involved in that, can we take his evidence or not? So all those things you can expect in a Saksha Samhita. Okay. So this will take time, but each and everything is important from your exam point of view. Even after this also you have to do homework on these three bills. Definitely you can expect questions on this in the upcoming exams, whether it may be KC or UPSC, in prelims or mains. For sure. ಬರ್ದಿಟ್ಕೊಂಬಿಡಿ, ಕ್ವಶನ್ ಇದ್ದೇ ಇರುತ್ತೆ. ಓಕೆ, ಯಾಕಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಒನ್ ಚೇಂಜ್, ಮೆನಿ ಚೇಂಜಸ್. ಸೊ ಒನ್ ಚೇಂಜ್ ಆದ್ರೇನೆ ನಮ್ಗೆ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀವಿ ಕ್ವಶನ್. ಮೆನಿ ಚೇಂಜಸ್ ಮೀನ್ಸ್ ಡೆಫಿನೆಟ್ಲಿ ದೇ ವಿಲ್ ಬಿ. ಸೊ ಒನ್ ಬೈ ಒನ್. ಸೊ ಪಾಯಿಂಟ್ 1, section 113 of the revised bill has modified the definition of the crime of terrorism to entirely adopt the existing definition under UAPA section 15. Okay. So Unlawful Activities Prevention Act is there. Under that, okay, so definition of crime of terrorism is mentioned. So I hope you remember we discussed the terrorism definition was very vague. Anything can be considered as terrorism. So now they have changed that, adopted that. The definition of the terrorism, crime of terrorism, is same in both as well as Nyaya Samhita as well as UAPA Act. Okay. The UAPA, often labeled as draconian, is defined as a terrorist act with intent to threaten or likely to threaten the unity, integrity, economic security or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people. See, you need to at least get the essence of this and write in the exam. We already know that UAP is also not, that is also very vague. It can be clearly seen in the, definition. See, an intent to threaten or likely to threaten unity, integrity, economics, security and sovereignty of India. See, very broad terms. Anything if it threatens, not already something is proven, threatens. If they feel it is threatening, they will take it as a terrorist act. Okay. So even if it creates terror in the minds of the people, so that is the basic definition. So earlier version of the bill included within, now at least even it was vague than this. Okay. See, there it is like earlier. Now it is changed. This we discussed after getting the feedback and everything. So after also getting the feedback from the parliamentary committees, so they are changing it. Okay. So earlier terrorist are vague because intimidating the general public or segment thereof, disturbing the public order, threatening atmosphere. See, very vague one. It was just a message, spreading the message of fear. Okay. Destroying the political, economic, social structure, creating a public emergency. So all these things, even non-violent speech could be categorized as a terrorist act. ಮುಂಚೆ ಈಗ ಅಟ್ಲೀಸ್ಟ್ ಅದನ್ನ ಸ್ವಲ್ಪ UAP ಲೆವೆಲ್ ತಂದಿದೆ. Even a speech can be considered as a terrorist act. But it is not exactly same. It is not exactly same. UAPA definition and Nyaya Samhita definition not exactly same. So what is the one difference? See, ನಿಮಗೆ ಇದನ್ನ ಯಾಕೆ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಿದ್ದೀನಿ ಅನ್ನೋದು ನೀವು ಆನ್ಸರ್ ರೈಟಿಂಗ್ ಬರೆಯಕ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದ್ ಹೊರತು ಗೊತ್ತಾಗಲ್ಲ. ಏನೋ ಹೇಳ್ತಿದ್ದಾರೆ, ಅಲ್ಲೊಂದಿದೆ ಅಂತ ಇಲ್ಲೊಂದಿದೆ, ಡಿಫ್ರೆನ್ಸ್ ಹೇಳ್ತಾರೆ, ಸೇಮ್ ಇದೆ. ನಿಮಗೆ ಮೇನ್ ಆನ್ಸರ್ ಬರೆಯಕ್ ಸ್ಟಫೇ ಇದೆ. When they ask, criticize, evaluate, analyze, okay, so then only this matters to you. Otherwise you will never remember. You have to try to write an answer. Okay, so then only you will, nim taleleno, now I am focusing on prelims, I should not write mains. ಆ attitude ಇಂದ ಎಲ್ಲಿವರೆಗೂ ಹೊರಗೆ ಬರಲ್ಲ, ಸಕ್ಸಸ್ ಬರಲ್ಲ. There should not be any difference between like writing mains, prelims or giving interview. Simply, okay, ಏನೋ ಇಂಪಾರ್ಟೆಂಟ್ 1 hour ತಗೊಂಡ್ ಮಾಡಿದಾರೆ, ಇವತ್ತು ಒಂದು ಕ್ವಶನ್ ಬರಿಬೇಕು ಅಂತ ಅನ್ಸಲ್ಲ ನಿಮಗೆ, ಅನಿಸ್ಬೇಕು, ರೈಟ್? ನಿನ್ನೆ ಎಕನಾಮಿ ಇದೊಂದು ಫುಲ್ ಅವರ್ ತಗೊಂಡು ಇವತ್ತು ಆಲ್ಮೋಸ್ಟ್ ಇದು, ದಟ್ ಮೀನ್ಸ್ ಅಷ್ಟೊಂದೇನೋ ಇಂಪಾರ್ಟೆಂಟ್ ಇರ್ಬೇಕಿಲ್ಲ. ಅಂದ್ರೆ 5 minutes ಅಲ್ಲಿ ಎಡಿಟರ್ ಕೆಲವೊಂದು ಸ್ಕಿಪ್ ಮಾಡ್ತೀವಿ, ಸಾಕು, ನೋಡ್ಕೊಳ್ಳಿ. ಕ್ವಶನ್ ನಮ್ಮ ಮೈಂಡ್ ಕಾಣಿಸಿರೋದಕ್ಕೆ ನಾನು ಅದನ್ನ ಎಷ್ಟು ಅದೇ ತರ ಡಿಸ್ಕಷನ್ ಮಾಡ್ತೇನೆ. ಸೊ ದೇ ಮೇ ಆಸ್ಕ್, ಏನಿದೆ, ಅನಲೈಸ್ ದಟ್, ನೀ ಹೆಂಗಿರ್ಬೇಕಾಗಿತ್ತು. ಸೊ ಯು ಡೋ ನಾಟ್ ಥಿಂಕ್ ಟೂ ಮಚ್, ಜಸ್ಟ್ ಟೇಕ್ ದಿಸ್ ಅಂಡ್ ರೈಟ್ ದೇರ್ ಆಸ್ ಯುವರ್ ಪಾಯಿಂಟ್. So new definition differs from UAP's definition in one respect, that is UAP includes the production or smuggling or circulation of only of high quality counterfeit Indian paper currency or coin or any other material within the ambit of terrorism, whereas revised bill widens the definition to cover the same activities concerning any counterfeit Indian paper currency. What is the difference? One line. It's of high quality, only it is mentioning there. Even if it is low quality or anything, yes, counterfeit currency means counterfeit currency. ಯಾರು ಹೇಳ್ತೀರಾ why they are differentiating like low quality, high quality and all?
Equality, differentiation of original note and
becomes very difficult. That only they have added in UAP. Now, whatever it may be, there are people to get, easily they can fool people. It is not so easy. Everyone will recognize the counterfeit currency. Counterfeit currency means it's a counterfeit currency. So that is also considered in this terrorism act. That is one difference. What do you feel? That is right. Nothing wrong about it. Okay. Counterfeit currency they are trying to do means nothing wrong. That is a of terrorism only against the economic security of an. In this, possessing a property derived from or through a terrorist act is punishable by only if he held knowingly. That is, somebody is having a fake currency note. By mistake, you are having that. Somebody has given to you. So, are you punishable under the terrorism act? Madbeka? You are having that. No. So, that's what they are saying, that this knowingly meaning, unknowingly it has come to my pocket. But knowingly, if you are having that, then it's a punishable offense. Okay. And harboring a terrorist is punishable. You can easily understand. You are giving protection to some terrorist. Here, they use the word voluntarily as well as knowingly. You know that he is a terrorist, and voluntarily, that means if he is threatening you at gunpoint and staying in your home, that is not considered as offense. But you know that, and also you are willingly protecting him, then it is a punishable. Artha madkobeku, each word matters. Voluntarily and knowingly. Knowing, yes, you know him, that is a terrorist. Voluntarily. Just voluntarily, you don't know that he is a terrorist, then no problem. Offense of recruiting and training persons engaging the terrorist act. Exactly, they are copy pasting that UAPA. Okay, 18A and 18B of UAPA. So, under criticism and all, you can what you can write one line. They are regularizing this UAP Act. And Salva. Till now, prevention of preventative detention. Almost it may be like POSA, TADA, POTA. All these acts are removed, but only one is UAP is remaining. Now, by adding this to this Bharatiya Nyaya Samhit, okay, it is like making UAPA regularized. Even in future, UAP is removed. UAP still will be there in this Nyaya Samhit. ಅರ್ಥ ಆಗ್ತಿದೆ ಅಂದ್ರೆ ಇನ್ನು ಎಲ್ಲದೂ ಅಲ್ಲ. ಐ ಆಮ್ ಜಸ್ಟ್ ಹೆಂಗ್ ಆನ್ಸರ್ ಬರಿಬೇಕಾದ್ರೆ ಯು ಕ್ಯಾನ್ ರೈಟ್ ದಟ್ ಅಂತ. ಸೊ ಇಟ್ ಇಸ್ ಲೈಕ್ ದೇ ಆರ್ ಪುಟಿಂಗ್ ದಟ್ ಪ್ರೊವಿಷನ್ ಹಿಯರ್ ಮೀನ್ಸ್ ಇಟ್ ಇಸ್ ಜಸ್ಟ್ ಆಸ್ ಗುಡ್ ಆಸ್ ಲೈಕ್ ಯುವರ್ containing UAPA forever. Because Nyaya Samiti will not be repealed so easily. It will be there forever. The explanation of this section allows an officer. Anyway. So who should act means officer level, that is a superintendent of police, that SP only should decide this, because it will be misused, lower level misused. Next, offense is punishable by death or imprisonment for life. Those who conspire, abet, incite, facilitate commission of terrorist act could face imprisonment ranging from 5 to life sentence. So artha agtide alla, maximum punishment is imprisonment for life, death. Helama.
Sir, in the above, only differences they have mentioned of high quality, paper currency.
Yes.
Or coins.
In that, remaining almost they copied the UAPA terrorism definition only.
Okay, sir.
Second biggest thing changes cruelty. Okay, ನಿಮಗೆ ಗೊತ್ತಿದೆ ಟೆರರಿಸಂ ಬಗ್ಗೆ ಯಾಕೆ ಇಷ್ಟೊಂದು ಮಾತಾಡಬೇಕು, ಯಾಕಂದ್ರೆ ಎವ್ರಿ ಡೇ ಇಟ್ ಇಸ್ ಹ್ಯಾಪನಿಂಗ್. ಬಟ್ ಅಲ್ಲಿ ಇನ್ನೋಸೆಂಟ್ ಪೀಪಲ್ ಆಲ್ಸೋ ವಿಲ್ ಬಿ ಅರೆಸ್ಟೆಡ್ ಅಂಡ್ ಪನಿಷ್ಡ್. So that's why what is there, we must be knowing the law. Okay. Next, now also it is vague only. UAP is not so easy. Anyone can be arrested under the act of terrorism. Okay, even for a small mistake, because the interpretation changes from person to person. Second is cruelty. So, cruelty against woman by her husband and relatives, which is punishable with a jail term up to 3 years. Okay. So, that also they have, So in this, section 86 defines cruelty as willful conduct likely to drive a woman to commit suicide or cause grave injury or danger of life, limb or health. ಯಾವುದೇ ರೀತಿನಲ್ಲೂ ವುಮನ್ಗೆ ಹರಾಸ್ ಆಗೋ ತರ, ಅವ್ರು ಸುಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳೋ ತರ ಮಾಡೋದು, ಅಥವಾ ಎನಿ ಡ್ಯಾಮೇಜ್ ಟು ಹರ್ ಬಾಡಿ, even to her health. It is even though mental or physical. Harassment of women to coerce her or any person related to her to meet any unlawful demand for property or valuable security, even with related to her property. So that is also considered as cruelty. Although the offense has now been defined in a separate provision, that is 498A of the IPC and 84 in the original bill. Okay. So ಮುಂಚೆ ಅಂದ್ರೆ IPC ನಲ್ಲಿ 498A is talking about the same thing. And section 84 in the original bill defined cruelty using same terms in their explanation clauses. So there is no new addition in effect in the revised bill. So they have maintained this cruelty definition like this only. Because there was so many criticism, but they have not changed this cruelty definition. Please understand to what extent it is considered, like even it may be mental, it may be just attempting, making her to make, like feeling to suicide and all, and also taking her property, encroaching her, all these things are considered as a cruelty. Next, third thing, court proceedings. So about court proceedings, what all the things are punishable? Suppose in this section 73, it is talking about court proceedings report publishing. Something is going in the court and you are publishing that in your newspaper, media or anything. Okay. So you have heard the term media trial? Media trial. Before something is, verdict is about to be given, before that only they will make somebody as culprit. They will only take their decision. Media. Some murder happened. They will show in husband is the murderer. So they will only give the verdict. Later court, decides that he is innocent. But by that time damage has happened to that person. Alva? And second thing, it influences the court. It influences the court. So that is called as media trial. That is why some restrictions are there with respect to court proceedings. Heng handle madbeku anta. See, those who print or publish any matter concerning court proceedings in a rape or sexual assault cases without permission would be punished with a 2-year jail sentence and time. So remember this. Because you know that they will do that whenever rape or something happens, they will only give their verdict. They will only half information. They will see. Judge may be saying that in prima facie he looks like a culprit. By highlighting the same thing, you will damage to his dignity. That is not final verdict. So that's why without the permission of the court, if they are publishing or printing, they are punishable up to 2 years jail. The explanation to this provision clarifies that reports on High Court or Supreme Court judgments would not amount to an offense within this provision. Okay, another point they are telling that. So reports on High Court or Supreme Court judgments, reports, please understand. Suppose Parliament has come out with some reports on High Court and Supreme Court. That report you can publish. ಅರ್ಥ ಆಗ್ತಿದೆಯಾ? ನಡೀತಿರೋಂಥ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇಂದ ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೋಗಿ ತಗೊಂಡು ಹೋಗಿ ಕೊಡೋಂಗಿಲ್ಲ. ಅಲ್ಲಿ ನಿಮಗೆ ಪನಿಷ್ಮೆಂಟ್. But some report is there on that High Court and Supreme Court, working of High Court, Supreme Court, how they are functioning, and that report you can discuss. No problem.
So here only they were given for 2 provision, right, sir? Rape and sexual assault.
Which one? Because that is only very highly sensitive. Okay. So for that thing, without permission, other things, see, for example, even people won't look. For example, somebody has stolen 10 rupees, they will not pay that much attention. But somebody has involved in a black mark on that person. They will isolate him. Okay, very damaging to the dignity. Article 21 violation. It is not like that in other cases, but everything you cannot prevent. In all cases, say for example, recently we saw one who stolen a buffalo 70 years back. Okay, we are not feeling like actually ಅವ್ರ ಮೇಲೆ ತುಂಬಾ ಸೊಸೈಟಿನ ಐಸೋಲೇಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರನ್ನ ಆತರ ಏನು ಫೀಲಿಂಗ್ ಬರಲ್ಲ ನಮ್ಗೆ. If the same news is about a rape victim, even if it is after 70 years, the ನಮ್ಮ ಇದು ಏನೋ ಇರುತ್ತೆ ಒಪಿನಿಯನ್ ಅಥವಾ ಬಯಾಸ್ನೆಸ್ ಇರುತ್ತಲ್ಲ, ದಟ್ ಇಸ್ ಡಿಫ್ರೆಂಟ್. So that's why they are putting that much restriction, because that only sense media will sensitize them and take, because of TRP they will do whatever. Okay, and another change with respect to court itself has come out with some words we will not use. I hope you remember that article we discussed. Court said that we will not, especially with respect to for women, describing women with some words, keep anta word use madodu, some words we will not at all use. That is against the dignity of the woman. So that one committee was set up to what word should be dropped. What word should be dropped from the judgments and all now onwards. So for that itself they set up a committee. Nenpidiya? Because it is talking about that. Here they are not using some words now onwards. Okay, that is called a regressive terminology. So for example, so like mental retardation, okay, and lunacy, unsoundedness of mind. Okay, now that is like hucha anta kariyodu. So that is not correct. So we better call it as mental illness. For other thing you call it as like disease, right? He's saying this illness, but for this you are terming it as labeling it as, so that now onwards that word should not be used. One example they are giving. So you better use mental illness. However, the panel pointed out that term mental illness is too wide. Its import could even include mood swings and voluntary intoxication. So they are telling that if you are saying, because some cases, no, they will relieve the culprit because of mental illness, even though he has done this murder. So it's not so much punishable. Send him to Nimans for further treatment. If you are saying that mental illness, that is like everyone is like having that mood swings. Okay, even now and then. So that mental illness is too wide. If you take that, so everyone quotes that because of mental illness. Okay, so there is a criticism you can add. As a result, the revised bill replaces the mental illness with the unsoundedness of mind. So earlier that mental illness was preferred. Now they have changed that word to unsoundedness of mind. So somewhat specific they have made. Okay, that means one who is not having the clarity of thought, one who cannot think, one who cannot act according to that. So for that person, you can say mental illness is everyone is having. That was the criticism. So now they made it as unsoundedness of mind. Even this can okay. Anyway, it has been added in majority of the provisions. It has been added the term intellectual disability along with the unsoundedness of mind in section 367. Okay. So one more word they are saying, intellectual disability. Means one who cannot think of ideology, one who cannot align himself with that. So that person, ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂದ್ರೆ ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ they will say that he is mentally retarded, give exemption to him. So judges will consider that. And now they are talking about will not use those words. So intellectual disability will use actually they made it broader, mental illness. But criticism, it can be misused like any. So they come up with the unsoundedness of mind. Is it clear? Next, another with respect to court. This is very important. Usually, mob lynching. What is mob lynching? ಗುಂಪಲ್ಲಿ ಹೊಡೆದು ಸಾಯಿಸ್ಬಿಡ್ತಾರ, ಗೊತ್ತಲ್ವಾ? ಎಲ್ಲರೂ ಸೇರಿ ಹೊಡೆದ್ರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಗುಂಪಲ್ಲಿ ಹೊಡೆಸ್ಬಿಟ್ಟು ಸಾಯಿಸ್ಬಿಡೋದು. They will be escaped easily ಅಂತ. Now here it clearly says, here they are This is also punishable offense. Okay. So mob lynching and hate crime are separate category of murder for the first time. Now they are considering that is also murder. Till now, ಗುಂಪು ಗಲಭೆನಲ್ಲಿ 4 ಜನ ಸತ್ರು, ಯಾರಿಗೂ ಅಂದ್ರೆ ಯಾರಂತ ಇದನ್ ಮಾಡೋದು ಅಂತ ಇತ್ತಲ್ವಾ. Now it is not like that. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, it is considered as a murder for the first time. The offense dealt with the cases where murder is committed by 5 or more persons acting in concert with one another on grounds of race, caste, or community, sex, place of birth, language, person, belief, or any other ground. Now they are making them accountable. If everybody's intention is towards the same thing, then it is considered as murder only. ಯಾವುದೋ ದೇವಸ್ಥಾನದಲ್ಲಿ ತುಳಿತಾಗಿ ಸತ್ತೋದ್ರು, that is not considered as a murder. But some intention is there among all the group members to hurt him, then it is considered as murder only. However, it was criticized by the panel for prescribing a lesser minimum sentence of imprisonment of 7 years as opposed to the offense of murder. But here, what they did is, for this, the punishment was less. ಅದನ್ನ ಕ್ರಿಟಿಸಿಸಮ್ ಮಾಡಿದ್ರು. ಮರ್ಡರ್ ಅಂದ್ಮೇಲೆ ಮರ್ಡರ್ಗೆ 7 years ಮಿನಿಮಮ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಇದೆ. ಓಕೆ, ಸಾರಿ, ಇಲ್ಲಿ 7 years ಇದೆ, ಅಲ್ಲಿ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಫಾರ್ ಲೈಫ್ ಇದೆ. ಬಟ್ ವೈ ದಟ್ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಅಂತ? ಓಕೆ, ಸೊ ನೌ ದೇ ಆರ್ it is exactly like original definition of murder only, means life imprisonment. That also they changed. When you are telling that it is a murder, then why the punishment is different? Punishment should be same. So now they have changed it. Correct alva? Murder is a murder andmele matte adಕ್ಕೆ punishment same irbeku. That they have changed. So next, fourth point. Ignore recommendation. They are telling that some recommendations were strong, means important, but they did not consider them. So ನಿಮಗೆ ಇವು ಆಕ್ಚುಲಿ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್. ಯಾಕೆ ಮಾಡಿಲ್ವಲ್ಲ? ಕ್ರಿಟಿಸಿಸಮ್ ಅವೇ ಪಾಯಿಂಟ್ಸ್. ಇದು ನೆನಪಿದೆ ಅನ್ಕೋತೀನಿ. ಸಪರೇಟ್ ಆರ್ಟಿಕಲ್, ಜೆಂಡರ್ ನ್ಯೂಟ್ರಲ್ ಪ್ರೊವಿಷನ್ ಆಫ್ ಕ್ರಿಮಿನಲೈಸಿಂಗ್ ಅಡಲ್ಟ್ರಿ, ನೆನಪಿದೆಯಾ? ಜೆಂಡರ್ ನ್ಯೂಟ್ರಲ್ ಇಂದ ಅಡಲ್ಟ್ರಿ ಐ ಎಕ್ಸ್ಪ್ಲೈನ್ಡ್. ಸಿ, ಹಳೆದೆಲ್ಲ ನಿಮ್ಗೆ ತಲೆಗೆ ಬರ್ಬೇಕು, ಬಂದ್ರೆ ಓಕೆ, ನೀವು ಓದ್ತಿರೋ ರೀತಿ ಸರಿ ಇದೆ. ನೋಡಿ ಎಷ್ಟು ಇವತ್ತಿನ ಆರ್ಟಿಕಲ್ ಅಲ್ಲಿ ಒಂದೊಂದೇ ನೆನಪು ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಕೊಂಡು ಬರ್ತಾ ಇದೀನಿ. ಅವತ್ತೆಲ್ಲ ಮಾತಾಡಿದ್ವಿ. Adultery we discussed, whether man have a illegal affair or woman have illegal. So who is punishable? Only man. So that also one article was there. This is it looks good, but it is not empowering women. It is treating women as a property of the man. That's why they are ನೋಡಿ ಅಲ್ಲಿ ನಿಮಗೆ ಪಾಸ್ಟ್ ವುಮೆನ್ ಎಸ್ಕೇಪ್ ಆಗಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಬಟ್ ಆಕ್ಚುಲಿ ಇಟ್ ಈಸ್ ಲೈಕ್ ದಿಸ್ ಇಸ್ ನಾಟ್ ಗುಡ್. ದಿಸ್ ಫೆಮಿನಿಸ್ಟ್ ಇದರಲ್ಲಿ. So they are actually taking as a property. Then only they are telling that woman is not punishable. ಆಯ್ತಾ? ಆ ವಿಚಾರದಲ್ಲಿ ಅಂಡ್ ಜೆಂಡರ್ ನ್ಯೂಟ್ರಲಿಟಿ ಬಗ್ಗೆ ಮಾತಾಡಿದ್ರು. ಓಕೆ, ಬಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ವಾಸ್ ಲೈಕ್, ದಿಸ್ ಈಸ್ ಅ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್. ವೈ ಯು ಆರ್ ಬ್ರಿಂಗಿಂಗ್ ದಟ್ ಇನ್ ಟು ದ ಭಾರತೀಯ ನ್ಯಾಯ ಸಮಿತಿ? ದಿಸ್ ಇಸ್ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್. If it is a sexual harassment, if it is a rape, if it is any violence, there are provisions. Let them come and give the complaint. But why you are adding here? So that was a criticism, but again they ignored it. So still these are kept open. For example, that criminalizes non-consensual sex between men, women, trans persons, and acts of bestiality has been left out in the revised bill. Okay. So with respect to this, so many recommendations were there. Okay, but they did not take into consideration. Actually, in 2018, Supreme Court, okay, that is Constitution Bench of Supreme Court, unanimously decriminalized adultery for being discriminatory and infringing upon the women's autonomy. Idra avattu matadidvi. Clearly, court has said this, adultery issue, okay, it is discriminatory against women and taking the rights of the women. So this is not correct. So they dropped it. But still in Nyaya Samhita, again they added it back. However, the panel reasoned that adultery should be criminalized in a gender neutral manner, since it is crucial to safeguard the sanctity of the family. ನೆನ್ಪಿದ್ಯಾ? ನಾವ್ ಯಾಕೆ ಇದನ್ನ ಇದನ್ನ ಮಾಡ್ತಾ ಇದೀವಿ? ಓಕೆ, ಮ್ಯಾರೇಜ್ ಸ್ಯಾಂಕ್ಟಿಟಿನ ಉಳಿಸ್ಬೇಕು ಅಂತ. ಓಕೆ, Section 377 IPC can be still be invoked when there is a non-consensual sex or rape of a man by another man. Okay, the woman can also initiate proceedings against her husband for unnatural sex under Section IPC. If, as per Nyaya Samhita, these acts are not offences, it means that victims of the sodomy, buggery, etc. will know how remedy. So that is the problem. ಇದನ್ನ ಮಾಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ರು. ಸೊ ಮೆನ್ ಬರೀ ವುಮೆನ್ ರೇಪ್ ಆಗುತ್ತಾ? ಮೆನ್ ರೇಪ್ ಆಗುತ್ತೆ. ಅದನ್ನ ಯಾರು ಕೌಂಟ್ ಮಾಡ್ತಾರೆ? ಓಕೆ, ಅದಕ್ಕೆಲ್ಲ ಪನಿಷ್ ಮಾಡಕ್ಕೆ ಇದು ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಆ ರೆಕಮೆಂಡೇಶನ್ಸ್ ನ ಬಿಟ್ಟಿದ್ದಾರೆ. ಹಂಗಾರೆ ಹೂ ವಿಲ್ ಟೇಕ್ ಕೇರ್ ಆಫ್ ದೀಸ್ ಕೇಸಸ್? ಯಾವ್ಯಾವುದು? ಸೊ ದಟ್ಸ್ ವಾಟ್ ಹೇಳೋದು. So unnatural sex, okay, from the husband side, and also non-consensual.
Sir, is it marital rape?
Marital rape, ಅದು ಇನ್ನೊಂದು ಡಿಸ್ಕಷನ್ ಇದೆ. They are talking about unnatural sex. Okay, so you can check the definition of unnatural sex. Okay, so that is also like harassment to women. That's why that is, but that is not added. ಅದನ್ನ recommend ಮಾಡಿದ್ರು. So hangare, if a man is raped by another man, where is the remedy? Nyaya Samhita should consider that also. Okay, see, woman rape ವಿಚಾರದಲ್ಲಿ ಅವಳಿಗೆ ಎಷ್ಟೊಂದು ಕೌನ್ಸಿಲಿಂಗ್ ಸಿಗುತ್ತೆ, ಎಲ್ಲ ಸಿಗುತ್ತೆ. Men suffers even worst. Correct? Because even if you go to police station, they will make fun of him. So he is very hesitant to go and give the complaint. Rape complaint ಕೊಡಕ್ಕೆ ಅವನಿಗೆ ಮೆಂಟಲ್ ಟ್ರಾಮಾ ತುಂಬಾ ವರ್ಸ್ಟ್ ಇರುತ್ತೆ. ಅಂಡ್ ಯು ಆರ್ ನಾಟ್ ಇವನ್ ಕನ್ಸಿಡರಿಂಗ್ ದಟ್. ಅರ್ಥ ಆಗುತ್ತಾ? ಕಾಮಿಡಿ ಬಿಡ್ತಾರೆ. ಓಕೆ, ಆತರ ಫೇಸ್ ಮಾಡೋದೇ ಬೇಡ ಅಂತ ಅವ್ನು ಹೋಗೋದೇ ಇಲ್ಲ. ಅಂತದ್ರಲ್ಲಿ ನೀವು ಅದನ್ನ ಇನ್ನೂ ಅದಕ್ಕೊಂದು ಪಾಯಿಂಟ್ ಕೂಡ ಆಡ್ ಮಾಡಕ್ ರೆಡಿ ಇಲ್ಲ. Okay, and also transgender, the same person. So if they are facing, transgenders or men are facing sexual offenses, there is no recommend. So this is a very strong point for your criticism. They ask now, criticize the bill. Okay, point happen. And one more change there is petty organized crime definition. Petty organized is a group. They plan it and dacoity or theft or something, organized crime, anything. So petty means small cases. Whoever being member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling, ivellavanu kuda, okay, is said to commit petty organized crime. Okay, ಸಣ್ಣ ಪುಟ್ಟ ಇದನ್ನ that's what is that ಅಂತ define ಮಾಡಿ all these cases. Now coming to second bill, that is Nagarika Suraksha Samhita. Okay, that is nothing but CRPC. So one important concept here is the community service as a form of punishment for petty offenses. Small offenses, for them, making them to do community service. That itself is a punishment for them. Okay. For petty offense such as an attempt to commit suicide, public servants unlawfully engaged in trade, okay, theft of property less than 5,000, 4,000 ರೂಪಾಯಿ ಕದ್ದಿದ್ದಾರೆ, 5,000 ರೂಪಾಯಿ ಕದ್ದಿದ್ದಾರೆ, public intoxication, defamation. Okay. So section 23 of the revised bill talking about this. That is, community service is a work which court may order to convict to perform a form of punishment that benefits the community. Okay, without giving any remuneration. ಅರ್ಥ ಆಗ್ತಿದೆಯಾ? You need to clean this area. No, they are punishment only. Small offenses. That is good move actually. ಆಯ್ತಾ? Moreover, magistrate of the first or second class has been ಅವ್ರಿಗೆ ಆ punishment ಕೊಡೋ ರೈಟ್ಸ್ ಇದೆ. And with respect to police, mainly handcuffing ಹಾಕೊಂಡು ಹೋಗ್ತಾರಲ್ಲ, ವಿಚಾರದಲ್ಲಿ Section 43 of the original bill permitted use of handcuffs to prevent the escape of individuals of serious offenses. Okay, but ಅದನ್ನ dignity violation, Article 21 violation ಆಗುತ್ತೆ. Panel recommended that please don't allow for all crimes to be handcuffed, only for heinous crimes like rape and murder. For that you have to, okay, so but that is also not considered. Actually, in this new CRPC, police have more powers for arrest and detention. Also, they have more powers. So compared to earlier, they have more powers. So this they are telling like we are protecting the rights of the people by giving more powers. You can criticize from the fundamental rights point of view. And one more thing, this is again negative part of it. First almost discuss positive things. Second, we are discussing negative. So court proceedings should be go in the audio visual mode. That means easily they should be public. But here, certain type of proceedings, okay. So for example, inquiries, trial before court session, trial in summary cases, okay, trials before high court, ಇವನ್ನೆಲ್ಲವನ್ನು delete ಮಾಡಿ. That cannot, not necessary that it should be given live streamed or something. Earlier it was there. Good thing. Everything is transparent. So you can defend also, you can also criticize also. Okay, because if you leak everything, sometimes it will change the fate of the case itself. Athara. But some new things they have introduced. ನಾನು ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ ಕ್ರಿಟಿಸಿಸಮ್ ಏನ್ ಆನ್ಸರ್ ಬರೀಬೇಕು ಗೊತ್ತಾ, ಅವನ್ನೆಲ್ಲ ರಿಮೂವ್ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, ಇನ್ ಕೇಸ್ ಆಫ್ ಫಾರ್ ದಟ್ ಕೇಸ್ ಇಟ್ ಮೇ ಬಿ ಡ್ಯಾಮೇಜಿಂಗ್, ಬಟ್ ಒನ್ಸ್ ದ ಕೇಸ್ ಫೈನಲ್ ಇಸ್ ಓವರ್, ಅಟ್ ಲೀಸ್ಟ್ ಯು ಹ್ಯಾವ್ ಟು ರಿಲೀಸ್ ದಮ್. Okay, so that you can ensure the transparency. But new things they have added that they did not, they are deleted. For everything, audiovisual mode is not allowed. But some new things like reading out of the charge to accused, hearing on discharge, examination of witness, recording of evidence. Okay, this should be done in the audio visual mode. Andre recording alle nadibeku. Later it cannot be changed. Okay, so like sections concerning sections. So I said police are given with more power. Police custody.
Sir?
Huh.
So is it necessary for us to remember all the sections?
No, not required. Not required. But in KPSC, there is a possibility to ask some sections also. But important with respect to women harassment related bill. Okay, it will appear in the newspaper. That repeatedly appearing means that your section you remember. ಈಗ ನೋಡಕ್ ಹೋದ್ರೆ ಎಲ್ಲವೂ ಹೊಸ ಸೆಕ್ಷನ್ಗಳೇ. ಇಟ್ಸ್ ನಾಟ್ ಒನ್ ಸೆಕ್ಷನ್. ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋ ಕಷ್ಟ ಇದೆ. ಬಟ್ which appears in news again and again, you remember that section. That they will ask. ನಿಮ್ಗೆ ಗೊತ್ತು, which is very important. Okay, revised bill, police custody beyond 15 days of arrest. ಅದನ್ನ ತಲೆ ಕೆಡಿಸ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟಿಲ್ ದೇ ಆರ್ ಹ್ಯಾವಿಂಗ್ ದಟ್ ಪವರ್. ಓಕೆ, ಯೂಶಲಿ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಇನ್ ಕೋರ್ಟ್, ಇನ್ ಮೂವೀಸ್ ಅಟ್ ಆಲ್ ಅಟ್ ಲೀಸ್ಟ್ ಯು ಹ್ಯಾವ್ ವಾಚ್. You cannot give more than 7 days, 6 days, because more time they are in their custody. Okay, that means police custody kotre harassment hengo ಮಾಡಿ ಒಪ್ಪಿಸ್ಬಿಡ್ತಾರೆ. Okay, if there is a need, then only they will allow. But here it is even beyond 15 days also it is allowing. Section 187, which corresponds to section 167 of the CRPC. Earlier in CRPC, now it is put in the Suraksha bill. The prescribed 15-day period of police custody can now be an aggregate or shorter period of custody sought over an entire period of investigation. ಅಂದ್ರೆ 60 days 90 days ವರೆಗೂ ಹೋಗಬಹುದು ಅಂತ. ಮುಂಚೆ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ 15 days ಮೇಲೆ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಮೋರ್ ಪವರ್ಸ್. ಅವ್ರು ಹೇಳೋದು ಸೊ ಇಟ್ ಇಸ್ ನಾವು ಪೀಪಲ್ಸ್ ರೈಟ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ಯೂಸ್ ಆಗೋದಿದು ಅಂತ. ಬಟ್ ದಟ್ ಈಸ್ ಡ್ರಾಕೋನ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಸ್ಟೋಡಿಯಲ್ ವೈಲೆನ್ಸ್. ಸೊ ದಟ್ ವಿಲ್ ಬಟ್ ದೇ ಆರ್ ಗಿವಿಂಗ್ ಜಸ್ಟಿಫಿಕೇಶನ್ ಲೈಕ್ ಇಟ್ ಈಸ್ ನೀಡೆಡ್. Okay, and the detained person must now be produced before magistrate or released in petty cases within 24 hours. Earlier, for every cases, it was like that. Now, for petty small cases, immediately we should produce within 24 hours. ಅರ್ಥ ಆಗುತ್ತಲ್ಲ? Then, third bill, that is Evidence Act. Evidence Act, that is the Saksha, Bharatiya Saksha Bill. So, this is talking about evidence. Can it be like WhatsApp? Can it be like Facebook? Electronic evidences. Okay. So this is not good. What they are saying is simply you cannot take the electronic record and say as the evidence. Earlier it was good. Electronic evidence is admissible. Now star mark they have put. So it is subjected to section 63. That means certificate is required whether this evidence can be considered or not. I can give positive also for this because anything can be created, fake can be created. Simply everything is admissible means. So that's why some sort of evidences should be certified. Positive bariyadare, negative bariyadare, it is not good. Correct alva? By default evidence should be accepted, but here they are putting star mark. That means certificate. 63 section talking about certificate. Artha aguttalla? Whether this can be admitted or not. In the light of AI, artificial intelligence, you can easily say that sir, this is correct. But now court is there. If you doubt, then you send it to forensic, right? Whether it is fake or something, that they will decide. Okay. Anyway, you can. So here justification that police power is given expanded. No, massive expansion of possible duration of police custody in the BNS strikes at a very heart of the civil liberties protection. Okay, ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಹಾರ್ಮ್ ಮಾಡತ್ತೆ ಅಂತ ಒಬ್ರು ಹೇಳಿದ್ರೆ ಇನ್ನೊಬ್ರು ಹೇಳ್ತಾರೆ ನೋ ದಟ್ ಈಸ್ ಓನ್ಲಿ ರಿಕ್ವೈರ್ಡ್ ಟು ಎನ್ಶೂರ್ ದೇರ್ ರೈಟ್ಸ್ ಅಂತ. ಸೊ ಇಸ್ ಇಟ್ ಕ್ಲಿಯರ್? ಹೇಗೆ ನೋಡ್ಬೇಕು ಒಂದ್ ಬಿಲ್ ಅನ್ನೋದಕ್ಕೊಂದು ಇದು ಕೂಡ ಹೆಂಗ್ ಓದ್ಬೇಕು, ಯಾವ ತರ ಕೇಳಬಹುದು, ಹೆಂಗೆ ನಮ್ ಕ್ರಿಟಿಸಿಸಮ್ ನ ಡೆವಲಪ್ ಮಾಡ್ಕೋಬೇಕು. ಅರ್ಥ ಆಯ್ತಾ? ನಿಮಗೆ ಮೋರ್ ಕವರೇಜ್ ಇಷ್ಟನೋ ಇನ್ ಡೆಪ್ತ್ ಈ ಕವರೇಜ್ ಇಷ್ಟನೋ? ನಾನ್ ಬೇಕಾದಷ್ಟು ಟಾಪಿಕ್ಸ್ ಬಿಡ್ತೀನಿ, ಯಾಕಂದ್ರೆ ಮ್ಯಾಗ್ಝಿನ್ ಇರುತ್ತೆ, ಅದೆಲ್ಲ ಇರುತ್ತೆ. ಮೋರ್ ಕವರೇಜ್ ಮೀನ್ಸ್ ಟಾಕಿಂಗ್ ಅಬೌಟ್ ಆಲ್ ದ ಟಾಪಿಕ್ಸ್, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್, ಇದನ್ನ ಓದಿ ಇದನ್ನ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಮಾರ್ಕ್ ಮಾಡ್ಕೋ ಅಂತ ಹೋಗೋದು. ನಾನ್ ಫೋಕಸ್ ಮಾಡೋದು ಮೇನ್ಲಿ ಕಂಡ್ರೆ ಹೇಳ್ತೀನಿ ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಅಂತ ಎಲ್ಲ ಹೇಳಿರಲ್ಲ. ಬಟ್ ಸಾಧ್ಯವಾದಷ್ಟು ಒಂದ್ ಟಾಪಿಕ್ ತಗೊಂಡ್ರೆ ಅದರದ್ದು ಜಾಸ್ತಿ ಅನಲೈಸ್ ಮಾಡಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ. ಯಾಕಂದ್ರೆ ನಿಮಗೆ ಮೇನ್ಸ್ ಪಾಯಿಂಟ್ ಆಫ್ ವ್ಯೂ ಅದು ಬೇಕು. ಪ್ರಿಲಿಮ್ಸ್ಗೆ ಏನು ಮ್ಯಾಗ್ಝಿನ್ ಹೆಲ್ಪ್ ತಗೊಳ್ತೀರಾ, ಸೊ ಮತ್ತೆ ಟೆಸ್ಟ್ ನಡೆಯುತ್ತೆ, ದೇರ್ ಯು ವಿಲ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಯಾವ್ಯಾವ ಕ್ವಶನ್ ಬೇಕು ಅಂತ. global goal on the adaptation and the road from Dubai. So you know that the climate summit ended. Right? So one serious decision is about whatever we discussed in Paris climate summit. So that we want to carry out seriously. So I'm not going to discuss everything. Just I'll give what they are talking about. So guided by Paris Agreement on global goal on adaptation. So there also we discussed. Here also we are discussing. Okay, I can highlight what is there in this article. What they're telling is, see, defining pollution or something, mitigating pollution, it is easy. But defining climate change is not so easy. It is not that. Simply, everyone is saying that climate change is happening, but there are no certain indicators. For pollution, you can say that, okay, so 2.5 particulate matter, 10 particulate matter, carbon dioxide, sulfur dioxide, all these things. What is the level? How to reduce this? It is easy. But in case of climate change, there are no indicators. ಅದು ಇದ್ರಾಗೆ ನನಗೆ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಅನ್ಸಿತ್ತು. So they are taking an approach, let develop the indicators. So then you can monitor them. You are telling like 1.5 degree reduction in the temperature. In general, you are talking. But 1.5 degrees, that is a very vague kind of thing, like only talking about temperature. How, what indicator, how to look into it, everything. Okay, existing indicators are not sufficient. That you have to develop. That is one important from this article. Okay. Other than that, they are talking about money, fund aspect. Okay. Everyone is talking about adaptation, but fund is required for that. Correct? So the global goal on adaptation, even in Paris Agreement, also same thing. Now they are focusing, yes, we have to take it very seriously, we'll do it. The efforts put in COP 26 and 27 were what culminated in the adaptation of framework, that is Global Goal on Adaptation, GGA, at COP 28. Earlier they discussed and now they finalized it. So they are focusing on that adaptation and mitigation should be given equal importance. This one point you can use it. We were talking about mitigation. Correct? No, you have to reduce that, this and all. Adaptation also should be equally given importance. Okay. And they are saying that average temperature below 1.5 degree compared to pre-industrial levels. But they are saying that it should be, 2.8 degree reduce ಮಾಡಬೇಕಾಗುತ್ತೆ by end of this century. Okay. So in this para, they are highlighting that. Right. See, measuring GGA. That's what I say. Measuring. That means adaptation also you have to measure what we are doing, how much it is performing. See, it is not very simple to answer whether progress of adaptation has been made because there are no indicators. Everyone is saying that we are adapting, but where is the indicators? Unlike mitigation of greenhouse gases, climate adaptation does not have a universal metric. ಅದಕ್ಕೋಸ್ಕರನೇ in this GGA framework, they have, ಒಂದು ಡಿಸಿಷನ್ ತಗೊಂತಾರೆ, ಇದೇ ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. So let us develop those indicators. Adaptation ಆಗಿದೆ ಅಂದ್ರೆ let us measure through indicators. Then only we can understand. This is ಅಂದ್ರೆ ಇದರಲ್ಲಿ ನನಗೆ ಈ ಲೈನ್ ಇಷ್ಟ ಆಗಿದೆ ಅಂದ್ರೆ ಆಲ್ವೇಸ್ ವಿ ಟಾಕ್ ಅಬೌಟ್ ಮಿಟಿಗೇಷನ್. ಅಡಾಪ್ಟೇಷನ್ ಮಾಡ್ತಾರಲ್ಲ ಅಂತಲ್ಲ, ಬಟ್ ಅಡಾಪ್ಟೇಷನ್ ಆಲ್ಸೋ ಇಸ್ ವೆರಿ ಮಚ್ ಇಂಪಾರ್ಟೆಂಟ್ ಲೈಕ್ ಮಿಟಿಗೇಷನ್. ಅದನ್ನ ಮಾಡಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ. ಸೊ 2 years ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಫೈನಲೈಸ್ ಮಾಡಕ್ಕೆ. ನೆಕ್ಸ್ಟ್ ದೇ ಆರ್ ಟಾಕಿಂಗ್ ಅಬೌಟ್ ಫಂಡ್ಸ್. Okay, so that you can go through, no problem. And quickly, I will explain in 1 minute this debt issue. IMF sovereign debt risk assessment for India has spurred a sharp reaction. IMF has given what is the India's debt situation. Okay, the finance ಏನಂದ್ರೆ ನಮ್ದು ಡೆಟ್ ಯಾವಾಗಲೂ ಡೆಟ್ ಟು GDP ರೇಷಿಯೋ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಡೆಟ್ ಟು GDP ಯಾರು ಹೇಳ್ತೀರಾ? ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ದಿಸ್? GDP is our national income. Out of that, how much is the total debt? Our 100 rupees is the income. In that 70 rupees is debt means. ಅರ್ಥ ಆಗುತ್ತಾ? So that's why they're talking. IMF has said that has given the level. So we are saying that no, we don't have that much. Always that is the scenario. Okay. Finance Ministry last Friday issued statement titled "Factual Position vis-a-vis IMF's Article 4 consultation with India." They have released. So IMF every year discuss with each country and they give the status, the financial health of that country. Okay, like what is your debt level? Okay. So this year also it has given IMF's correct economic and financial information and discuss policies with top officials before preparing a report. ಅರ್ಥ ಆಗುತ್ತಲ್ಲ, ಅವರೆಲ್ಲ ಬಂದು ಎನ್ಕ್ವೈರಿ ಮಾಡಿ, so collect all the information how actually the government is performing, then only they will announce such things. Ministry statement 4 days after IMF released its latest Indian consultation details. Certain presumptions have been made taking into account possible scenarios that does not reflect the factual position. Idu namma government view. So that is considering the future thing, they have given this. That is not actual position. Anta yaru helidare? Government helidare. In particular, Minister was referring to IMF view that adverse shocks could lift India's general government debt to beyond 100% of GDP. ಅದರಲ್ಲಿ ವರಿಂಗ್ ಫ್ಯಾಕ್ಟ್ ಯಾವುದು ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ತನಗೆ, ಯಾಕಂದ್ರೆ ಅಹೆಡ್ ಎಲೆಕ್ಷನ್ಸ್ ಆರ್ ದೇರ್. ವಾಟ್ ದೇ ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ IMF ಇಂಡಿಯಾಸ್ ಡೆಟ್ ಲೆವೆಲ್ ಕುಡ್ ಕ್ರಾಸ್ 100% ಆಫ್ ದ GDP. ಅಂದ್ರೆ ನಿಮ್ಮ 100 ರೂಪಾಯಿ ನ್ಯಾಷನಲ್ ಇನ್ಕಮ್ ಇದೆ, ನೌ ಇಟ್ ಇಸ್ 70-80, it will cross 100 also anta, but government stand is not 70-80, even it is less anta. IMF is projecting it will cross 100 anta. 100 ರೂಪಾಯಿ ಇನ್ಕಮ್ ಸಾಲ 110 ಚಿಲ್ಲರೆ ದಾಟುತ್ತೆ, ಆಯ್ತಾ? ಸೊ ಮಿನಿಸ್ಟರ್ asserted this was only worst case scenario, not fate accompli ಅಂತ ಹೇಳ್ತಾ ಇದೆ. What IMF is telling that in worst case it will happen like that, not the real scenario. IMF country reports show much higher extreme worst case scenarios. For instance, ಬೇರೆ ಕಂಟ್ರಿದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, 160, 140 and 200% of GDP for US, UK and China. ನಮ್ಗಿಂತ ವರ್ಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಂದ್ರೆ ದಟ್ ಈಸ್ ವರ್ಸ್ಟ್ ಕೇಸ್ ಸಿನಾರಿಯೋ, ನಾಟ್ ಇಟ್ ಈಸ್ ಹ್ಯಾಪನಿಂಗ್ ಅಂತ ಅಲ್ಲ ಅಂತ. ಓಕೆ, ಎನಿವೆ, ವಾಟ್ ಈಸ್ ದ ಪ್ರೆಸೆಂಟ್ ಥಿಂಗ್? 81% of the debt GDP in 22-23. Earlier it was 88. Sir, ಚೆನ್ನಾಗಲ್ವಾ? No, it is COVID time. It can be expected. So 81 is not correct. So they are saying that positive side, worst case you are highlighting. The IMF itself says it can go to 70% by 27-28. ಇನ್ನು ಕಮ್ಮಿ ಆಗುತ್ತೆ, ಇನ್ನೊಂದು 5 years ಹೋದ್ರೆ it will even 3-4 years come down ಆಗುತ್ತೆ. And there are another highlighting, IMF staff perception of India's fiscal position is improved compared to past years. Okay, ನಂಬರ್ ಎಲ್ಲ ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋದಲ್ಲ, ಜಸ್ಟ್ ಪೇ ದ ಅಟೆನ್ಷನ್. ಈ ತರದ್ದು ಒಂದಿದೆ, IMF give forecasts, okay, and government argument regarding the same. And on a 1 minute I will take for this. Carry on, doctor. again with respect to this new bill, Bharatiya Nyaya Samhita, IPC. If because of doctor's negligence any death happens, earlier there was an exemption because of Indian Medical Association says that he tries to protect in all possible ways. In that case, death happens. So give him exemption. Exemption was given. But there are many cases where doctor negligence leads to death. Okay. So that is punishable now. Okay. That is punishable now. But only difference they have made is
reduce the number of
that's what punishment years they have reduced. This case, one no, not necessary to remember, Jacob Bathy versus State of Punjab case. So negligence should be gross. ಸಣ್ಣ ಪುಟ್ಟ ನೆಗ್ಲಿಜೆನ್ಸ್ ಎಲ್ಲ ನೀವು ಹೋಗ್ಬಿಟ್ಟು ಇದು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇಟ್ಸ್ ತುಂಬಾ ದೊಡ್ಡ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. A significant high degree and consequently criminal liability would be come up only if the physicians can be demonstrated. Okay, his ಆದ್ರೆ ಅವ್ನ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಗಿದೆ ಅಂತ ಪ್ರೂವ್ ಮಾಡಿ. Okay. And they are talking about punishment. ಇಲ್ಲೆಲ್ಲ ಇದೆ. ಮೇಲ್ಗಡೆನೇ ಇದೆಯಾ ಎಷ್ಟು ಕಂಪೇರ್ ಟು ಅದರ್ punishment, for example death and murder or something, right, that is higher, but for doctors it is 2 years. Panel recommended 5 years, so they said 2 years. If because of their negligence something is happening, so they have to face 2 years punishment. No one is above the law concept. Please use that.